All right, Delegate, we're live.
Thank you. Welcome everybody to a brief morning session of HRP Subcommittee on March 20th. As we get closer to crossover, just a heads up, there will be some, sporadic meetings, so bear with us. We have a list of a few bills. We might add one more if time permits. We're going to go in the reverse order. I know we have 402 and 1501. We want to make sure we have the exact amendments before we move forward on those. We're just getting those clarified. For now, we're going to start on House Bill 1073, Landlord and Tenant Residential Leases, Prospective Tenant Criminal History Records Check, Maryland Fair Chance and Housing Act. We had a group of amendments that came in. I'll let Ben give us a full update, but just for the quick background on this bill, what this bill does is pretty much allow for landlords to create pretty much a hold so that they can, people who have certain types of records can be considered. They will then be well. I'll let Ben describe. But one of the things we had with the bill issue was the fiscal note. The amendment addresses the fiscal note concerns to make this bill way more workable and create more opportunity for those who are looking for housing. But Ben, if you want to quickly describe the bill, and then we'll march through the amendments really quick, and then we can discuss.
Okay,
Thank you.
thank you. Thank you, Mr. Chair. So this bill, it concerns prospective tenant criminal history records checks and then the procedure for doing so. As amended, the bill applies only to landlords that manage four or more residential units. What the way it works is a landlord that conducts a criminal history records check is required to do so for all prospective tenants. Before accepting an application fee, the landlord has to provide a prospective tenant with written notice regarding the use of criminal history in their leasing decisions. And it's disclosing a statement that it's for a conviction for a crime listed, and then there's a list for those. The next thing, the amendment strikes the offenses that a landlord can consider after the tenant screening report comes back, or after the criminal history records check comes back. So it says here, after the extension of a conditional offer, the landlord may conduct a records check and consider the following convictions, such as a felony conviction that occurred within the 3 years immediately preceding the application. A landlord can withdraw this conditional offer based on their criminal history if the landlord determines that that withdrawal is necessary for a substantial, legitimate, and non-discriminatory interest. If they withdraw the offer, they have to provide that tenant with notice. This is going to be a statement of the specific reason. There's a reassessment of the application at the request by the tenant, and then a landlord cannot knowingly publish or cause to be published an advertisement that states the landlord will not consider a prospective tenant who has been arrested or convicted of a crime. And then a landlord's decision to lease a residential dwelling unit or to obtain a criminal history records check cannot be the basis for a claim against the landlord. There's a provision about that. The Office of Tenant and Landlord Affairs for the Department of Housing and Community Development is required to develop and publish on their website a model notice for use by landlords. This is going to include things that advise a prospective tenant that the landlord has withdrawn a conditional offer, and language to notify the prospective tenant of their right to request a copy of information that the landlord relied on related to the criminal history records. And then there's a penalty provision, and then a requirement that DHCD adopt regulations.
Move the amendment.
Well, okay. Well, we can move the. Well, I wanted to take questions real quick first. So we'll wait on a second on that. Delegate Adams.
So I just want to work backwards. This is the kind of bill that if we can get it in the right posture, I would support, because I believe in generally the principle of giving people the opportunity for housing under these circumstances, provided we're giving the landlords enough opportunity for making a independent decision. But my hang up is it still feels like we have this penalty provision under the unfair, abusive, or deceptive trade practice. And so when I was reading the Attorney General's letter of information, they went into some length about the dollar amounts of the penalties and the number of like you could have stacking violations under the bill as drafted. So two questions. One, are we still in that place where the Attorney General's letter of information applies? And then and two, if we are, would there be appetite for the committee to revisit this penalty part of the bill? Ben.
I'll let Ben answer that where we are in regards to that letter, and then we can discuss more. Go ahead, Ben.
Yeah, thank you, Mr. Chair. I'm not sure if any of the advocates on the call have anything else to maybe add to that. I don't want to,
Let me see.
but I'm not seeing stacking though, Delegate Adams. I was just seeing that's the penalty provision that I'm seeing is at the end of the page. Maybe that's the same one you're looking at.
Yeah, so the Attorney General's letter written on March 3rd was a letter of information, not support or opposition. And in paragraph 2 of that, it speaks to the violation. It says that the civil penalty can be up to $10,000 per violation, and that violation, how the law is being written, in theory, a landlord could be making 4 or 5, maybe 10 independent violations if they have a standard policy, and their series of applicants perhaps have the same problem. So the point that they're bringing in this is when I say stacking, it's per violation. So that's my concern. But what it does say, and maybe confirm, it appears that there are no criminal penalties. I'm not sure how we're able to carve that out, but it looks like to me that maybe they're aiming at a different section of the Consumer Protection Act, such that we're not worried about so that's kind of where I'm at with it right now.
No, I hear you. That's a valid concern. I'm trying to. Does anyone from the? No, I assume no one from the Attorney General's office is here.
And then, Mr. Chair, if I
Yeah, go ahead, Ben.
Yeah, just try to answer that as quickly as I can. So there is it is carved out for, I believe, the criminal penalties. That's that part in the bill where it says except section 13411 of the commercial law article. And then the amendment reprint that does strike that they're subject to a civil penalty not exceeding 1,000. But that's all I guess I would add, Mr. Chair. Yeah.
Thank you. So,
Mr. Chair.
Chris,
Oh, sorry.
no, 1 second. I'm going to go down the list here. Chris, is that the last of your comments on the bill? Is that the only thing you had? I'm going to let Wyville.
Yeah, you can continue. I can see the $1,000, but the Attorney General's letter does go to the $10,000 per violation. So I'm going to keep reading, and I'll keep listening to other questions.
All right, thanks, Wyville, and then I think Delegate Charkoudian after that.
Thank you, Mr. Chairman. I know you would be disappointed if I didn't ask. Does the bill still have the $235,000 fiscal note in year 1 and going forward?
So my understanding is that due to how the bill sponsor worked really hard to change up the responsibilities of who's responsible for enforcement and the administrative stuff, my understanding is that the fiscal note is under 100,000 now, so it's no longer that high. It's $100,000 fiscal note, but the sponsor's not here to give more details on that. So, and I don't see someone from their office. Ian, have you reached out to their office to see if someone can join, just for clarification? But I'm pretty sure we sat and walked through the bill yesterday on the floor, and I'm not you, Wyville. I don't have the accounting experience, but my understanding is that the bill was significantly lower. That was one of the major hiccups on the bill, and I'll let council weigh in on that. And then is that all you had, Wyville? Do you have another question?
No, that was it.
Okay, go ahead, Ben.
Okay, thank you, Mr. Chair. We received an email from DHCD saying that they can implement, based on the amended bill, implement the bill using existing resources to the fiscal note. And then there's, I think I didn't get more of a specific analysis for that, but the page 9 there, they're striking the requirement that the Office of Tenant and Landlord Affairs and DHCD maintain data related to complaints. So.
Got it.
you.
Delegate Charkoudian, you were next.
Yeah, thanks. So two things. It was my understanding based on our emails back and forth that I saw with DHCD that it took care of it, but I think that was all of the fiscal note. It was that reporting and database. I was actually wondering, I thought I saw Zafar Shah from Legal Aid. I think that I'm wondering if he can weigh in on the penalty provisions. Did he leave or is he still here?
I'm still here. Thank
Oh,
you.
is that okay, Mr. Chair, if we ask him to
Yeah,
weigh
that's
in
fine. Yeah, I
how
know
the
he's.
penalty
Yeah,
provisions work?
I'll let him weigh in. And then, yep.
Just a point of information to Delegate Adams' concern. So the civil penalty provision, this is commercial law 13-410, does have the language about $10,000 and up to $10,000 up to $25,000 dollar penalties per violation. But I do want to just point your attention to subsection D of that statute, which makes clear that Consumer Protection Division is not absolutely every time going to impose that amount of penalty. They have 5 factors under a shall provision. So it says shall consider the following: 1, severity of the violation, the good faith of the violator, any history of prior violations, whether the amount of the penalty will achieve the desired deterrent purpose, and number 5, whether the issuance of a cease and desist order is insufficient for protection of consumers. So there certainly are mandatory factors that mitigate against the type of stacking that you're talking about, Delegate Adams, but also even in an amount. So I'll leave it at that. I just want to clarify that.
Got it. See here.
I have a follow-up.
Yep. Go ahead, Adams.
Could I ask the landlord advocates to kind of weigh in real quick since we?
No, that's fair. I think if we heard from Zafar, we have to be about being balanced. So
I don't know if Aaron's on the phone or somebody with
Aaron, or I know Brian from Iowa is here as well. If you either I think if you want to let Brian speak, or Brian, are you here?
Yeah, I'm here. I'm happy to speak to this. And I know Aaron is on the call as well. Brian Amley from the Apartment and Office Building Association. I'm over in the Senate and the Judicial Proceedings Committee. So apologies for having the camera off. Yeah, we were concerned about the very steep penalties. One of the things that we requested in the Senate and that the JPR committee has tentatively agreed to is to keep the unfair, abusive, and deceptive trade practice language, but cap the penalties at 500. So I think that addresses some of our concerns about how high some of these penalties can go and the penalties being stacked on top of each other.
Mr. Chair. Oh, I'm sorry.
Yep. Go ahead, Adams.
No, somebody else was weighing in there.
Mr. Chair.
Was Gabriel going to answer as
Yeah,
well?
I was going to add Gabe Auteri with Harris Jones Malone, and we represent the Maryland Multi-Housing Association. And so I think we share Brian's concerns about the penalty provisions. And I don't know, Delegate Adams, if your question was specific to how we feel about the penalty provisions or how we feel about the amendments and the bill generally. But I'd love the opportunity to share how we feel about the amendments.
If the chair will allow it, I would say briefly, just because I think
So I want to be balanced here, and we're running short on time, and I don't want to rush a bill that everyone's not fully understanding. I want to send over if we're going to send this out, we want to send the best product available. We also have someone from the OAG's office here that I want to make sure that we get some more clarification, because that's really what we started this conversation on. So Gabe, I will give you literally 45 seconds, and then we're going to go to the OAG's office to deal with the unfavorable language not unfavorable, I'm sorry, the language that they discussed in their letter. And then we will see if we have the ability, if the amendments address those concerns or what they're talking about. So Gabe, I'll give you literally 90 seconds, and I will turn it over to OAD's office.
Thank you, Mr. Chair. I really appreciate it. Really quickly, I think number one, there are some offenses that I think from a public policy perspective, we landlords should be able to look at initially and not waste an applicant's time. And so those are serious drug offenses, drug trafficking with a handgun, serious violent offenses. And we can provide an interlineated and a written copy of all the amendments that we recommend. The second is, I think that it's important that where the potential tenant is providing information, that information requires some level of honesty and transparency. And so if it's evidence, that it should be written evidence under penalty of perjury. Third, I'll say this bill in its entirety only deals with crimes that are only convictions that come from Maryland courts. If a potential tenant commits a rape in Pennsylvania, that is equally as relevant as a tenant who commits a rape in Maryland. And so I think expanding this to include equivalent offenses in other states and under federal law is really important, because it's the same amount of relevance whether it's in Maryland or Virginia or Delaware. And then the third piece, or the fourth piece I'll say, is just, we want to make sure that in the penalty consideration that the registration for landlords is the appropriate amount of time. And so it says 3, we would strongly prefer a 1 year. Hopefully
Thank you. Yeah, thank you. Right at 90. Good job. All right, I'm going to turn it over to
Thank you, Mr.
OAG's office, and I know we're still waiting on amendments from the other bills, so we can spend more time on this bill, but I know that, again, we might lose some members due to other time commitments, so we'll do our best to address these concerns. And at the end of the day, if we move this bill, we still have the time to add more amendments or anything between now and the full committee vote. So I don't have a subcommittee process working well this year in ECM. So I'm gonna turn it over to the OAG's office real quick. I think I saw her. Where is she? There she is. All right.
Yeah. Good morning, Chair.
I know. Yeah. I want this. If you can walk through your concerns on the penalty piece, because I want to make sure that we're being thoughtful there.
Yes.
And if the amendments that we currently have address any of that, and we'll consider maybe some changes. Thank you.
Yes. Thank you so much for your time this morning. The central concern of the division in terms of the penalty provision as the way it was drafted was that it actually creates an inconsistency in enforcement for the division. Our penalty provision provides for up to $10,000 per violation. And so as the bill was drafted, limiting it to 1,000 would create an inconsistency in the enforcement ability of the division. The amendments that have been proposed, striking just the $1,000, completely addresses our concern. And as Mr. Shaw pointed out, the $10,000 is just the upper limit of our penalties. It is not the mandatory penalty. There's 5 factors that we review when determining penalty amounts, including the good faith nature of the violator, whether restitution is sufficient to provide relief to impacted consumers, and whether there needs to be potentially a stiffer penalty to deter future violations within the marketplace. But I'm happy to answer any questions that you might have.
No, that's helpful. So Bandari, are you still on a motion to the amendments right now, or you have another question?
No, a question. Seems like the bill
go ahead.
is going out a little bit. Yeah. So my understanding is thank you for explaining that civil penalty is limited now. There's maximum penalty is $1,000 per violation, right? So
$10,000 per violation. Yes.
1,000, right?
$1,000
per violation, right?
Sorry, and under the Consumer Protection Act presently, the maximum penalty is $10,000 per violation. As the bill was drafted, it would limit the penalty amount to $1,000 per violation, which would be an inconsistency in the ability of the division to apply the Consumer Protection Act as proposed.
And quick question. And so with the amendment, I'm looking the amendment. So it applies only to landlords with 4+ unit, right? That excludes owner occupies property, right? I'm looking page 3, and it protects small, like a mom and pop landlords from new regulatory burden. Is that correct?
I think that would be a correct assessment, but Ben, if you have a different opinion, please.
And when criminal history can be considered before a conditional offer, now with that is more targeted and structure reviewed. I see here in safety protection, a landlord can still consider sex offenses, right? Murder, human trafficking, and felonies within recent year, right? Is that correct?
I would let Ben answer that question. I mean,
Yeah,
our
Ben.
central concern was really just about the inconsistent penalty amount. Not
Yeah. So I think, so real quick, before Ben goes, just so I understand the amendments, I think the amendments on penalties that the landlords are offering might address the Attorney General's issues. So I'm trying to, if someone on, whether it's Brian, Gabe, someone from, if y'all can explain just the penalty cap provisions of your offered amendments real quick again, just so I want to make sure we get all this lined up to make sense.
Thank you, Mr. Chair. So the recommendation that we would have is to strike on page 10, strike lines, I believe they're 16 to 21, and insert a violation of this subtitle is subject to a civil penalty not exceeding $500 for each offense.
Okay. And then OAG's office, would that bring us in alignment? I don't know if we agree on 500, but does that bring us to alignment?
No.
No.
No, because it would create an inconsistent penalty violation for CPA violations, which would be difficult for the division to perform.
So
in its enforcement.
So what would be the correct fix here for you all to be able to enforce properly?
Mr. Chair, I'd like to weigh in on this question too.
Okay, let me let the OG's office finish. Go ahead.
So our understanding was that there was a proposed amendment by the striking at page 10, lines 23 and 24. So the proposed bill now would read: a violation of the statute is an unfair, abusive, or deceptive trade practice within the meaning of Title 13 of the Commercial Law Article, and is subject to the enforcement and penalty provisions contained in Title 13, except for Section 13411 of the Commercial Law Article, which is the provision within the CPA that a violation of the CPA can also be considered a misdemeanor. And so the way that the sponsor proposed the amendment would be consistent with our ability to enforce the Consumer Protection Act in violations of the proposed bill.
So the amendments, for clarity, the amendments offered by this bill sponsor address the concerns that you all brought forth in your letter?
Yes.
Okay, so going back to the originator of all of this, Delegate Adams, are you satisfied with that answer there? Then I'll go to Delegate Charkoudian.
Like super far from satisfied with that. And here's the reason, because now we're saying this is just a straight up non-amended application of the unfair, deceptive trade practice, which, if I understood counsel right from OAG, that's going to include a misdemeanor potential. Is that no? I'm seeing you shake your head no.
I'm sorry. No,
right.
The way the bill is written, it would exclude a potential misdemeanor violation, which is currently provided under
all
the
right. All right. So, Mr. Chair, basically, we're back to $10,000 per violation. And I'm just going to make, Vice Chair is going to have a weigh in on this, and I get it. This has been like my classic concern with applying the Consumer Protection Act so broadly and in so many different ways. I mean, I think as a committee, we should probably choose where it's important, where it's not, and where you need that sort of enforcement, where you don't. We're not talking about discrimination. We're not talking about safety of housing. We're talking about an application process. My recommendation, and I'll stop talking, is that perhaps we should evaluate this not through the lens of OAG enforcement, rather through the lens of what happens if there's a violation and is there a penalty that could be applied. But to say that we're going to leave it to OAG's office, 10,000 per violation, okay, fine. Maybe they won't hit the mom and pop that has 20 or 30 units. But if you're a large property owner and something happens where you make a mistake, that's stacking. I mean, I don't deem that there's a cap to any of this. So you're leaving it to the good faith of OAG, and I get it, and I trust OAG to make fair decisions. But man, oh man, I mean that's the kind of thing where does this kind of legislative policy rise to the occasion, as I've said in many different bill hearings, of this sort of enforcement action. So my recommendation would be to find a way to strike the Consumer Protection Act here. And if you want to put a penalty in, we do that all the time in our committee. So that's my last word.
All right, thanks. I'm going to go to Charkoudian quickly. We haven't heard Lily. Delegate Chi wants to chime in. I want to make sure we have equal voices here, but I know you wanted to talk to this specifically, Delegate Charkoudian. Go ahead.
Yeah, thank you. So I just want to make sure we understand what I feel like there's sort of two different conversations. And so the conversation about penalty is one thing if we were to sort of arbitrarily say we like this amount of penalty or that amount of penalty, but I just want to make sure that we're clear that the proposal that's on the table of sort of shift it to $500 as a penalty essentially strips the Attorney General's office out of it completely. So if we want, as I understand it, and the AG can correct me if I'm wrong, if we want the AG to enforce this, which I believe we do, then we need to tie it to the Consumer Protection Act. Because if we don't tie it to that, then they're not in a position to enforce it. And so then it's in private enforcement. And so then we're in this situation where you have people who barely have resources because they're just trying to put their lives back together, trying to come up with a way to privately enforce this. And so I guess if the AG can just confirm to me, if we don't line it up with the CPA, then is there something else you would be able to do to get these $500 or whatever number we think is fair? Or is the only way that you can enforce this is if we tie it to the CPA? Can you confirm that?
It would be easiest to tie it to the CPA, and because it would direct the Consumer Protection Division to investigate and potentially enforce this law. If the penalty provision isn't tied to the Consumer Protection Act, then it is less clear which division within OAG could enforce this statute. I mean, there are certainly ways that the Consumer Protection Division can try to enforce consumer-facing protective statutes, but it becomes a little bit more murky and would require additional legal analysis and work on our part.
And so I think that this committee has talked about like, okay, you either have the AG or you sort of have right of private action. And if you're going with right of private action, then you add attorney fees and treble damages and whatever else. And we've generally shied away from that, although I'm in favor of it, and moved towards we want the AG to enforce it. So if we want the AG to enforce our fair housing law, we have to make sure that they actually have the tools. And right now that structure is through the Consumer Protection Act. So I just, for me, I understand the concern about really high fines, but I think that the AG has different levels of and different things to consider. And so the fact that there's a $10,000 cap doesn't mean that people are getting $10,000 fines, for their first violation of this. And I think that we do trust the AG to enforce our laws, and this is the way they enforce all of the consumer protection laws. So I just think it's really important that we're not just talking about what are the different fines, we're actually talking about what is the enforcement mechanism. Thank you, Mr. Chair.
Yep. Delegate Chi, we haven't heard from you.
Thank you. Good morning. I want to just chime in response to what I heard since the AG is here. So my question to OAG is, do you have any data of the average fines in these kind of circumstances? Do you usually go all the way up to 10,000? And what is the average amount in this particular situation where there's, maybe inadvertent mistake or ill-intended mistake, however you categorize it. And also, but more importantly, my question is, if we don't go with the CPA standard, consumer protection, which could be lumping a lot of things, industries into that, right? Housing might be slightly different. If that's the argument from the housing community, then, what would it be a set of laws that could be better governing this kind of penalty? If it's not consumer protection? Do you have like a landlord-tenant kind of situations that we could potentially carve out something here?
So I'll start with the first question, and please correct me if I'm wrong, Delegate, that your question was, how often do we go up to the full 10,000 in civil penalties in our final orders? And I can tell you that in my history with the division, which dates back 7 years, I have not seen a $10,000 civil penalty for a single violation. We do very religiously and detailed in our final orders go through what the factors are to consider when issuing a civil penalty, and they are typically much, much lower. And I would say usually much lower than $1,000, which used to be the cap pre-2018. I believe that merchants, including landlords, are already covered under the Consumer Protection Act in terms of their interactions with consumers. So I could leave your additional question of whether there are other spaces to tenant advocates if you were to strip out the consumer protection division from this bill. But I think having it clear that these kind of consumer-facing interactions between landlords and tenants in this space in terms of applications and information that's provided to them at the front end squarely falls typically within the enforcement authority of the Consumer Protection Division and in spaces that we've typically operated in, including in interactions between unfair and abusive and deceptive actions of landlords with tenants.
Thank you. I just want to make sure, and I appreciate your response. To be fair, I know, from all these years of serving ECM, I know how OAG thinks, your mindset, right? Your job is to protect consumers. But we also need to ensure fair market play to make sure that businesses continue to want to operate in the state of Maryland while protecting consumers, ensuring fair market play. That was why I asked that question. So, I heard your comment earlier about it will be easier for you to enforce. It's not our job to make sure it's easier to enforce. It's our job to ensure fair market play, right? We do what we need to do as a government in response to that. So I just want to offer my comments here. We should do it the right way instead of making it easier for OAG to enforce just because it's more convenient or something. That should never be an argument. I just put it out there. And I'm not saying this is, we should not be putting under CPA. That was why I asked whether there is a better alternative. It doesn't sound like you have right now.
Yeah, well, I'll offer, and I'm sorry I'm not on screen, folks. My internet's becoming unstable, so unfortunately, you don't get to look at this beautiful face. But at the end of the day, I think when it comes to enforcement, I think the other piece, Delegate Chi, is the costs, right? So if you're able to put something, I agree that we should be doing our best to make things, to make our markets fair and make sure we have business thriving. But the other part is the cost on the state. If we're able to give responsibilities to certain groups, it makes it more cost efficient for the state. So that's my understanding of some of these decisions that we make. It's also about cost efficiency and manpower efficiency for our state. So we have to it's always that delicate balance of how do we do that? But I think your comments are, in alignment as far as like we do have a job here, and thank you for saying that and making sure that we are creating a viable economy here. But I'll turn it over to Aaron real quick. We got to get off here in like 4 minutes. I know folks are late for meetings and people are driving, so
I'll only take 3.5. I guess based on comments, I think we keep legislating things, and when you put that $10,000 number out there, and somebody can get that, contrary to what the AG says, but you're stifling landlords harder and harder in each thing. And landlords aren't nasty. They do not, these things are happening. I agree with that. But I think when we keep piling these penalties on, and they can happen, whether we believe they will, you're discouraging the landlord problem. And landlords are already scrutinizing things. They're fear of everything we do. And when we add a big number like this, they just sit back and they say, you know what, I'm going to do everything I can to protect me within the law. And we may never get to the point where we have this problem, but we just can't keep putting that onus on them, because it's not the greatest business in the world. These aren't all wealthy people we're talking about. These are people like you and me that maybe have a house we're trying to build some wealth on, and they see this, it's going to limit what their participation would be. And I would rather stick with the 500. I think we need to police this. I think there are areas that could be addressed and help some people, but that's not the purpose of the bill, to punish some of the good people, which can happen.
Yep.
That's all.
No, thank you, Delegate, and I appreciate those comments. Here's what we're going to do. We're low on time. I think the best way to move forward, we had a motion to move the amendments. I'll take a second on that motion to move the amendments, and then what we'll do is we will consider the bill as amended. If we get there, I'll let the body do that, and then what we'll do is, again, we'll have time between now and the full bill hearing to consider if there's any opportunities for us to do any kind of numbers moving on the penalties. I just want to be thoughtful here on time and make sure that we allow folks to get to, because there's a few other bills moving around in Annapolis other than this one that I know folks need to get to and talk about. So I'll let
Mr. Chair,
Joe.
Mr. Chair.
Yes.
Yeah, listening all these concern about the penalty, and I think the committee wants a moderate penalty. I feel kind of not great, comfortable to move the amendment now. Is that okay, or we could discuss in the committee whatever
So
way? I want to withdraw the.
So you're withdrawing your motion. So I just want to be clear on what I'm saying here. So if we were to move the bill, we would have time to deal with the possible penalty changes between now and the full committee meeting. So I'm just, if we delay this, we have to do another subcommittee meeting. I'm trying to make sure that we get this to a position where we can
Mr. Chair, yes, if we could, sorry, I'd like to move the amendments and the bill with an understanding that we'll continue to discuss the penalty between now and when we have the full voting session.
Right, and if we don't get a chance to, even before we just, I would, you all have seen me operate, I'm a man of my word. I would hold the bill in a full vote if we haven't had the opportunity to make a decision and hear things out. I just don't want us to, we're on the Friday for a crossover. I don't want us to have to keep re-meeting on this bill. So I want to make sure that
That's
we're
correct,
in a
and we
position.
don't want the discussion to delay the opportunity to vote on this bill before crossover. So I'd like to move the amendments.
Yeah, if that is the will of the subcommittee, Mr. Chair, I will second the Madam Vice Chair amendment.
All right.
Can you repeat what the amendment does again?
The amendments are primarily what the amendments do is they take care of the fiscal note. So they remove all of the stuff that the DHCD had to do in terms of the database that caused the fiscal note. The second thing that they do is they change the penalty piece. And so that's the part, I mean, this is a package amendments. So that's the part that I think we're saying is still up for discussion. So.
Yeah. So are you, and Delegate Chi, if you're not satisfied with that, Ben, do you need Ben to explain any further, Delegate Chi?
So the second part that the Vice Chair mentioned, is that the one of the that includes the $500 as part of the package amendment?
No, the $500 offer was made by the group here from the housing community. So we're going to consider that after we move the bill before we go to full committee. So we'll figure out if we can get to a place on. I want us to be able to get this bill in a position to where we can move more swiftly. So I'm a man of my word. I want to hear out on how we can make the penalties work, because I think we've had a rich discussion and there's been some valid points made, but I just want to be thoughtful on time. So the amendments have been moved. There's been a second. All in favor of the amendment, say aye.
Aye.
Aye. All those in opposition say no. The amendments have been adopted. Is there a motion to move the bill as amended? And again, we're moving the bill as amended. We will consider more amendments later. There's a motion to move the bill as amended. Is there a second?
Second.
All right, second. We have a second. All those in favor of moving the bill as amended.
Are we going to have discussion on this or not?
Oh, I'm sorry. The bill's been moved and seconded. Discussion. Go ahead.
All right.
Discussion.
So last bite on this penalty thing, and OAG's here. Here's what happens. The OAG will send a citation or whatever to the landlords. They will threaten up to $10,000 per violation. And the reason why the OAG can come back and say, well, they don't usually get to $10,000 is because they bring the full weight of the state of Maryland on these landlords and say, we'll negotiate with you. We won't take $10,000 if you don't go to court or you don't fight us. Hey, maybe you can do $2,000, maybe you can do $3,000. And it's not right to pass this bill with the penalties and then hear the testimony from OAG when I know that's how they act. And it's not a good practice, and it's deceptive to say, oh, we never do $10,000. No, they threaten it every time and use it as a leverage piece against these small businesses. It's wrong. We're moving a bill before it's ready for prime time. So I'm going to vote no on the bill.
All right. Thank you, Adams.
Mr. Chair, can I, on the discussion, I just want to remind us what we're talking about. We're talking about people who are coming out of prison who need a place to live. And all of the research shows that if people have a place to live, they're less likely to reoffend. And so that crux of this, if we don't address this issue and make sure people have a place to live, then our communities are less safe. And we are going to pay more and more money as a state for locking people up. And I just like, we're talking a lot about enforcement piece of it, which is important, but I want to just bring us back to why it is that it's really important that we pass this bill, even while we're discussing some of the specifics of it's about our future budget for the Department of Corrections, and not spending as much there. And it's also about safety in our communities. And so just want to keep that front and center. And that's why I'm voting for this bill.
Thank you. Real quick, Aaron's real quick.
Yeah, I appreciate the comments from both people, but we also have to talk about the people who have done no wrong, who are sitting out here trying to make a living, trying to provide for what they've done. They aren't the person who actually committed a crime, and we have to understand when they did commit a crime, it was a crime. And I apologize if some people are being slighted, but you have a lot of people out there trying to build their families, build their wealth, and this is their vehicle for that. If we keep infringing on that, we're going to damage the people who have played by the rules and have done nothing wrong. I think we need to protect these people, but not at the expense of the people that have no guilt in this, and they are potentially going to be harmed by this bill. And I agree with Delegate Adams. Just because we say we haven't done 10 grand, I can promise you I've seen it. But thank you. I'm done. I'll be a no on the bill.
All right. Thank you. All those in favor of the bill say aye. Raise your hand. Let me sure I can see you. I mean,
No.
I guess I'll
No.
So I just want to make sure, on the record, I just want to say I'm voting for the bill with the understanding that we'll come back to this penalty.
Yes. No. We're gonna come back, and if what we'll do is we'll discuss, and then if there's an amendment we want to offer, we'll have an amendment ready for main committee. But again, it doesn't, and we might not, we likely, just looking at time, it might not be a vote. I can almost promise it won't be a vote today. It'll probably be a vote if we vote it out tomorrow in committee. So I want to make sure we have time to work this out. I don't want time to get
clarity for everyone. I guess I want to make sure for clarity, and I think to answer Delegate Shee's comment, if we don't work it out, some people who may have voted yes now may be voting no later. Is that what we can say?
Of course,
Okay.
you can always, with new information, you always have the right to change your vote, for sure.
Understood. So I think that is clarity.
No, for sure. All right. So this vote is just to get the bill in the posture for us to be able to possibly add more amendments and make more changes. So I just want to, it's about time at this point. So with that said, all in favor of the bill say aye, or raise your hand so I can see it and we can move forward. All right, Delegate Charkoudian, I assume you're aye. All right, all those in opposition, I think we heard from those folks. And is Weibel, you're not on the screen. I assume, are you a yes or no on this? The physical note's good for you, brother. I can't hear you.
I appreciate that part of it, but I have to be a no right now.
I got it. All right. Thank you. All right, everyone. We're gonna move on and get out of here because I know folks got to get to where they need to go. Motion to adjourn.
Motion to adjourn.
Second.
Yep. All right. We will likely have another meeting later today, most likely to discuss the other bills we were still waiting on amendments for, but listen to the floor, and then we'll see you all soon.